The concept of smart contracts was first proposed by Nick Szabo in 1994. He described them as computerized transaction protocols that executes terms of a contract.
Szabo would go on to more rigorously define smart contracts in his 1996 book, Smart Contracts: Building Blocks for Digital Markets, where he defined them as a set of promises specified in digital form, including protocols within which the parties perform on these promises. The smart contract operates virtually on blockchain, which is a public ledger that utilizes computer algorithms to validate and execute decentralized transactions, where decentralized means that no one party or individual has control over the process.
To put it into perspective, suppose Mike and I enter into a contract. I agree to pay him money once he delivers a book to me. The contract is written as code into blockchain. Once Mike performs the act of delivery, the smart contract executes itself and the money will be sent to Mike. On the other hand, if Mike does not deliver, the transaction will be automatically cancelled and the money will be returned to me.
It should also be noted that a smart contract is not necessarily legally binding. Like all agreements, smart contracts can take on a number of forms, and whether it is a legally binding contract will turn on the particular terms, facts, and applicable law.
There are a few key features of smart contracts. First, it is digitized. The transaction occurs virtually, and in most instances without an intermediary. Second, it is pseudonymous, meaning that the parties are identified not by their name, but by their ID or address. Finally, it is immutable. Once a smart contract is created, it cannot be changed.
Far and away, the most common application people use for smart contracts is Ethereum, an open-source, public, blockchain-based platform and operating system. Ethereum uses different computer languages, such as Solidity and Serpent, to write and program digital contracts. Ethereum's method of exchange is their own aptly named Ether, an electronic cryptocurrency generated by the platform itself, with currently over 98 million coins in circulation.
This may all sound pretty confusing, but smart contracts actually have a lot of relevance to our course material. In 2018, a US Senate report said, while smart contracts might sound new, the concept is rooted in basic contract law. With that in mind, let's try to examine smart contracts from the contract law perspective.
Even what are normally some of the most basic questions in a contract law analysis get interesting when it comes to smart contracts. For example, how is the language of a smart contract drafted? Who drafts the language of a smart contract? In smart contracts, unless you're good enough of a programmer to code your own agreement, drafting is done ahead of time by the smart contract itself, by which we mean its programmer, which the parties simply select and agree to. Now, virtual contracts that use pre-made or standardized agreements to set out their terms are nothing new. In fact, when a smart contract is created, it often generates a document in human-readable or natural language format that makes sure us non-robots can understand the terms.
What really sets the drafting of smart contracts apart from virtual contracts is their capacity for a streamlined and transparent transaction process at a minimum and known cost. Thanks to blockchain, the contracting process can run without human intervention, using a hard-coded sequence of steps monitored and executed by an encrypted system. Proponents of smart contracts say that many kinds of contractual clauses may be made partially or fully self-executing, self-enforcing, or both. All of these characteristics help smart contracts provide security that is superior to traditional contract law and to reduce other transaction costs typically associated with contracting.
However, there are potential downsides to this automation. The sample contract for a book between Lucy and I included a set of terms dictating our obligations and the flow of consideration in the event I failed to perform, but a poorly chosen smart contract might lack such contingencies. Furthermore, even if the smart contract does have terms for that eventuality, the terms may be contained and executed by the back-end coding of the blockchain, which means they wouldn't be apparent in the terms of the natural language contract, if one is generated at all. This is a potential recipe for confusion.
Another interesting issue in smart contracts is what constitutes consideration. Many public ledger blockchains, including Ethereum and the better-known Bitcoin, rely on their own intrinsic cryptocurrencies, Ether and Bitcoin, to facilitate, validate, and authenticate transactions. Originally, cryptocurrencies were just digital currencies with their value based purely on speculation. With various countries opposing their use, it was particularly difficult in the past for them to be exchanged for traditional currencies. This poses the question of whether they can be treated as consideration. However, with cryptocurrencies becoming more readily adopted by financial and consumer markets, they're increasingly being backed by traditional currencies and commodities. One of the most recent uses of cryptocurrencies on Ethereum is to issue tokens that adhere to an Ethereum-based standard known as ERC-20. Such tokens are not intrinsic to the Ethereum blockchain, but are compatible with an Ethereum wallet and can be integrated into other Ethereum token smart contracts.
This means that a smart contract implemented with the ERC-20 standard can enable the creation of a digital token on the Ethereum platform that represents any fungible good, like currency, gold certificates, loyalty points, IOUs, or in-app credits.
Finally, these issues bring us to the matter of enforceability and the challenges that may be faced by the various parties in the event of contractual disputes. First, without clear consideration, the identification of legal parties, and natural language contract terms, smart contracts may be rendered legally unenforceable. Problems such as no obvious identifiable parties due to the use of pseudonyms and ambiguous events like system errors can make smart contract disputes more complicated. These issues are exacerbated by the fact that there often isn't a centralized administering authority to provide a body of rules to arbitrate smart contract disputes outside the judicial system, while the courts are also behind in their understanding of smart contracts. Lastly, due to the lack of technical expertise on the part of the courts and the limitations posed by blockchain's immutable language, courts may struggle to interpret or sever the contract terms.
Blockchain technology offers some potential solutions to these problems. Where the distributed ledger does have a central administering authority that has the ability to add remedial transactions, the parties could agree that this authority has the power to arbitrate any disputes, either as part of their contract or as a condition accepted upon participation in the ledger. Of course, this solution is only possible where such a central authority exists, and in cases where it doesn't, the parties are unwilling to use it, or it's impossible to examine a transaction without the consent of all participants. Such a solution may not be possible. In such instances, dispute resolution may have to be built into the smart contract itself, a technically tricky proposition from both a legal and a technological perspective.
In conclusion, while most literature predicts that smart contracts will never fully replace natural language contracts, smart contracts still offer a lot of potential to the commercial world, promising new levels of transactional efficiency, auditability, cryptographic security, reduced risk, and legal streamlining.
However, with these new possibilities comes a dizzying new array of legal complexities and technological challenges, which will require similarly innovative legal and technical expertise to overcome. We look forward to seeing how this new frontier of contracts develops. Thanks for watching.
Bye bye!